Alright folks, here's a vlog on the rather mysterious and technically termed Precedent H, which as a litigant in person you might have come across, and you kind of scratched your head and wonder whether or not you have to address it, whether you have to file and serve it, and also perhaps, and stay tuned for the golden nugget of legal knowledge, whether or not there might be an opportunity in disguise here. And so whether it's perhaps best not to completely ignore it, even though the CPR says litigants in person don't have to file and serve a Precedent H. Now, what is Precedent H? I don't know why the powers that be decide to give such, technical, opaque terms to describe what is, at the end of the day, a simple budget. It's just an estimate, a forecast. It's more than an estimate because you can be held to it, of what it is that you're going to spend on legal costs for the duration of the case. This all happens at the Costs and Case Management Conference. Now, it's only relevant if you're on the multi-track. If you're on the small claims, fast or intermediate tracks, you don't need to worry about this Precedent H, and your opponent doesn't need to worry about this Precedent H, whether they're represented or not. If you are on the multi-track, and you'll see this from the directions questionnaire for multi-track cases, it's got a little bit of a box towards the bottom of the form where you have to tick, you've filed your Precedent H at least 21 days before the Case and Costs Management Conference. Big moment in civil litigation. Yeah, you heard it here first, and you'll hear it here last. Costs are a major issue in civil litigation, yeah. They often override the substance of the claim itself because of they simply exceed the substantive value of the claim itself. So, yeah, on the multi-track, and I'll put up the relevant civil procedure rules reference, parties are required to file and serve a Precedent H if they're represented. Litigants in person don't have to file and serve one. Okay, I'll come on to explain why, even so, it's important for you to know about this. Right, so I just want to explain to you why I actually think this is a little bit of an opportunity for a litigant in person. And the reason is because your opponent may have instructed a law firm, in this example, for argument's sake, I'm saying that your opponent has instructed a law firm, and therefore they're under a lot of pressure. The stakes are raised for your opponent if they're represented. You may be, quivering in your boots, worried about, some Exocet missiles that are going to explode at you from some Linklater Blue Circle, mean-spirited, aggressive civil litigator. Don't be beguiled. Your opponent, behind their lawyer who's writing all the nasty letters, is sweating it in a multi-track case where his lawyer will be filing and serving this Precedent H forecast of legal costs, which could be very high, and it puts a lot of pressure on their client. Yeah. The pressure isn't just whether or not you've got a strong case, and we know that from the zillion videos and the zillion times that I've mentioned that to you. It's all very well having a Spitfire, but you've got to either be an experienced pilot or have a really decent navigator or control tower. Ka-ching, mini plug there for the book and our services at Court Wingman. Or you're going to have to, work really hard if you haven't instructed a lawyer, and stay focused on, the management and the conduct of proceedings and procedures so you don't end up on the wrong end of a costs order. Here's an opportunity where you can spin things round, if you like, and put your opponent under pressure. Now, the first way of two that you can put your opponent under pressure is by turning up at that Case and Cost Management Conference ready to attack their costs. Now, we see this, or Daria sees this. She's had a case recently where she's had a Precedent H from an opponent in the case she's litigating, And, you know, it's got like 20 hours for preparing a witness statement. And you can tell that the solicitor, and believe you me, it's a real headache for solicitors filling in this extremely complicated looking spreadsheet. Yeah, they're only allowed to bill like 2 hours for it. It takes them 5 hours. You know, so they just throw big figures down. They don't really work out how long, in fact, it is going to take for them to draft up a witness statement. Yeah, and they just err on the side of convenience, and they just over-egg the pudding in order to be conservative and play it safe. Fine, but they should watch out, because what happens at the CCMC is that the judge will take a hatchet to their costs. Now, the thing is, as we know, judges are extremely busy, and one judge may be very aggressive towards a cost budget, and another might not. He might just have a huge pile of cases he's got to get through that day, and he wants to just approve the Precedent H's. Yeah, so you're there to challenge that, to take one example of many, the 20-hour figure for a witness statement. Now, look, the problem is litigants in person often think that they shouldn't be thinking about costs, but they should, for the reasons I've just been stating. And so they should prep up, not just on the substance of the case, but they should also look for opportunities to score a tactical advantage. I mean, it can be difficult for you to, work out what is 20 hours de rigueur for drafting a witness statement, yeah? And actually this is a moment where it is worthwhile using a support service like Court Wingman. I mean, I know obviously I plug our services because I think we provide this excellent sort of soft touch approach, like a control tower or a navigator to a pilot, at judicious points of the litigation cycle. Yeah, drafting your particulars of claim. Yeah, we can draft them for you, or we can assist. Case and cost management conference, why don't I pick up the phone for an hour and ask Court Wingman, look, is this costs budget, is my opponent's Precedent H greatly inflated? And as I say, for the reasons I've just alluded to, this happens a lot, and it's an opportunity for you to put your opponent on the back foot. You see, because if you get a judge to slash your opponent's cost budget down from 80 to 50, and that sort of discount, can and does happen, then you create a friction. You create what's the correct word for this? You potentially drive a wedge between your opponent and their lawyer, because someone's got to have to pick up the shortfall of 30k, and in this wonderful new world of fixed costs, yeah, and with the powers that be trying to drive down solicitors' costs in litigation to make it proportionate, you can apply pressure by making the solicitors, be anxious about billing for work that ultimately at cost assessment they might not get. I've talked about costs a lot on my YouTube channel, and you'll be aware from a recent vlog on cost recovery that, traditionally, a court, either at summary assessment or at detailed assessment, could slash a party's costs down by 75%, and that can be even higher now with the fixed costs regime. Yeah, so in short, this is an opportunity for you to win a minor, or it could ultimately be rather more than minor, tactical victory over your opponent, and these hearings are all about bringing your opponent to the negotiating table. Yeah, once you've got your opponent hurting, particularly if they're a defendant whose strategy is to stick their head in the sand, which is the strategy of most defendants, you know, this is gonna be a big wake-up call for them. Okay, so now here's the second reason why it's quite important. This is the opportunity that I was talking about earlier. All right, so now I've often spoken about breaches and non-compliance with court rules, orders, directions, yeah. And if you read my book and so on, you'll discover that actually breaching a court order is not the end of the world, frankly, and a lot of people think that it is. But the fact is the courts are underfunded and understaffed, and they're making errors, and they forgive other people who also make errors, particularly if they're litigants in person. Yeah. Now, as I said earlier, the requirement for filing and serving, that's sending to court and sending to your opponent, sending to your opponent, is that it's done at least within at least 21 days before the hearing itself, you know, or whatever date has been ordered by a previous order. So you might think, well, okay, if they've missed the deadline by a day or two, it's not going to have any impact. Well, news just out, in the area of Precedent H, the courts are especially draconian, where people miss the filing and serving deadlines. Yeah. There was a case, Mitchell, the MP, and a number of years ago now, and then another case called Denton, which basically has reinforced the idea that if you file and serve a Precedent H late, you will only be able to recover going forward the court fees. And that's something that's enshrined in the CPR and has been explained and evolved in the case law, those two cases that I mentioned, Mitchell and Denton. Now, Mitchell was extremely draconian. You missed the deadline by a minute. I mean, that's massive. And your opponent doesn't get a penny of their legal costs paid for the rest of the case. Now, Denton followed Mitchell, and it diluted the draconian nature of it. It really was draconian. But now it's still quite tough, and it's still quite serious. And I tell you, you know, talking from the trenches when we're litigating cases, we've had these situations where we had a situation where there was a problem simply with our electronic filing, and we missed a deadline. Fortunately, the court took a view that it was just and, you know, a technical glitch. But here's the thing. We were forced to make an application for relief from sanction. I should just hasten to add, it's the only time I can remember missing a Precedent H deadline. But this is the problem. If you miss the deadline by even a minute, then you've got to make an N244 application for relief from sanction, because the sanction that's kicked in a second after, you know, the deadline has been missed is that you won't get any of your legal costs repaid going forward except your court fees. So now we've got a case recently where we're advising a litigant in person where, because you may not think that a seasoned lawyer would miss a Precedent H deadline, you know, would you, having heard what I've just said? Unfortunately, at the end of the day, life is all about keeping the eye on the ball. Litigation is all about keeping your eye on the ball especially. And unfortunately, lawyers, more often than you would imagine, make errors. There's just so many moving parts in a piece of litigation, and solicitors are human, and solicitors are fallible, and they're under pressure, etc., etc., etc. So we've had this case where we've where the deadline has been missed, and we've advised our client, a content person, to make to challenge this and raise it at the CCMC, which could potentially put their opponent under massive pressure. They're a litigant in person, their opponent is represented. Now, you might be asking, okay, fine, you've spouted a lot of law and case law at me. If I do decide to make a song and dance of this at the hearing, what arguments should I run and what is the legal test? Okay, so the legal test was laid down by Denton, and it's a three-pronged test, and the first test was the breach serious or significant. Okay, the second test is why the default occurred. So, for example, take our case. The default occurred because of a technical glitch with the computer. You're unlikely to win, aren't you? Because you're not going to pass that test. Whereas if it was a belligerent solicitor saying, well, I don't believe it's a multi-track case, they write to the litigant in person, the opponent, and they say, we're not going to file and serve a Precedent H. And I'm alluding to actual case law here, the facts of the case where this happened. Then, and it comes to the hearing, then, the reason the default occurred there was because a lawyer got the law wrong. In this case, they'd got, as I recall, they'd got a judgment against their opponents. They thought that they didn't have to file and serve a Precedent H, so they got the law wrong. Forget the circumstances of that case. The point is that, if a solicitor gets the law wrong, belligerently refuses to file and serve Precedent H, then boom. The third prong of the test is, and again, this is if you read my book, it's like this is like a touchstone that runs throughout how the legal system of England and Wales works. Is at the end of the day, the judge has got a discretion to do whatever he wants. So the third test is looking at all the circumstances of the case. Yeah. So there's always a get out of jail card for the judges. And the appeal judges, because they can say, well, the lower court judge took into account all the circumstances of the case. We weren't there. He probably made the right decision. Yeah. So it's a kind of a clever greyness that helps. So those are the three tests of Denton. Now, just stepping back and trying to give you guys a steer on, when you're likely to win for a late or non-filing and serving of Precedent H. I think the best way to look at it is just to put yourself in the judge's shoes, and you've got, here's the hearing, and you've got this party who's failed to file and serve it. Are you really going to basically depth charge a party's entire case by saying you're not going to get a penny paid from here on in, unless it's serious and significant? Yeah. So now it might be serious and significant, and the other two tests are met. If it's actually caused a bit of a problem, like it's last minute, and you haven't had a chance to go through an opponent's Precedent H, you haven't had a chance to prepare arguments as to why their Precedent H is, grossly inflated. You haven't had a chance to do what I was saying earlier, attack a 20-hour witness statement and so on. So that might hit a seriousness threshold. If let's say it's filed and served on the morning of the hearing or the day before, and the judge is starting to wonder, is this a bit of a tactic? Where a solicitor's been sly, where they've kind of tried to pretend that they did file or serve it. might play in a judge's mind. You know, he'll love to punish a solicitor if he gets a chance, even though he probably was one. Well, he was probably a barrister actually. So yeah, he loves to get one over on a solicitor. Yeah, so that may be a factor. On the other hand, and I'm touching on another case here where this actually happened. What happens where an opponent, a party filed, I sent to court in time, but didn't serve it? Well, you can see, you know, again, step back and use your common sense. That party who didn't get it served on them, had an opportunity to challenge it. Now, maybe if the Precedent H was very conservative, what I mean quite low, it was, you know, very proportionate and reasonable and worked out, then you know the judge may forgive that party. But what if it's in front of someone who has served very, very late and massively inflated their Precedent H? And in one of the cases, the judge made a discount of 50%, because remember, he gets at his hatchet, so he used that late filing to hatchet down the cost. So that's probably a possible, potential likely outcome where you feel that there has been a serious and significant breach. And as I say, that, you know, the facts of the case, why it was filed and served late, are material. So I would just sort of finally say on this point, and again, this came up in the case law, that remember the third prong is what were the in all the circumstances of the case, in all the circumstances of the case. In other words, a court is allowed to look at whether or not there's been any other failings by the party, where they've been naughty previously. So where they've been non-compliant with an earlier court order, let's say, or they've been obstreperous. You don't often get to use that word, do you? I don't really even know what it means, but it seems to fit. When the case was, let's say, at the pre-action stage, they didn't properly comply with the pre-action protocol. So, to come on and to conclude, you're in a potential box seat as a litigant in person at that CCMC in respect of filing and serving Precedent H's. And you should not only hammer those 3 points home, you should also step back in the way that I have and bring to the court's attention other failings by the party who's in breach of the Precedent H requirement. Note, 2 sides of the coin here, if you have failed to miss court deadlines, it might be unwise to make a song and dance at the hearing about late filing of Precedent H. Yeah, important note. And just as a sort of a caveat to what I've said, you know, when a party has been in breach, and then they must then make an application for relief from sanction, a judge could take a dim view of you if you've opposed their relief from sanction and filed and served a massive witness statement with loads of exhibits, when actually all they've done, to take our example, is miss by a matter of minutes the 21-day deadline because of a technical, glitch. Yeah, a judge could then punish you. So be careful. You do need to make sure that there's merit in the matter. Okay, so finally, at the hearing itself, remember you as a litigant in person don't need to do a Precedent H, and thank God, because it makes a solicitor's head bleed just trying to go through it, let alone a litigant in person. Nor, incidentally, do you have to file or serve a Precedent R, which is a budget discussion report. Now, although you don't have to do those things, I recommend, and in fact, a lot of solicitors don't do the Precedent R either. They just, major on the Precedent H, that's well enough. But I would just, write up notes on a piece of paper laying out the areas in which you propose to challenge your opponent's solicitor's Precedent H to try and get that figure down, both to apply pressure, but also if you were to lose, you won't have as big a cost bill to pay, damage limitation, thinking ahead. And if you are faced with someone who's missed the deadline, and you think there is merit, then file and serve your own witness statement and your exhibits in response to their application for relief from sanction. Make sure the court's got it, make sure your opponent's got it, and turn up at court ready, perhaps, to capitalise on a golden opportunity to bring your case to conclusion, or at least favourable settlement. Okay, it goes without saying, I don't know whether this is a very English thing, not being able to plug, because an American wouldn't have a problem with it. This is definitely an area in which it is a very good economy, cost-effective, costs-wise. Don't be penny-wise and pound-foolish to get a lawyer to assist because of the technical nature of these sorts of applications, and to give you an experienced sounding board as to whether or not there is any merit and whether you should be challenging a Precedent H that's been filed late. Incidentally, some opponent solicitors, for fear of being punished by a judge for unnecessarily challenging the late filing of a Precedent H, often will say in correspondence, we remain neutral on the issue, which is rather a clever way of not opposing the application for relief from sanction, requiring you to make it, and then, having a crack at the hearing itself. Okay, thank you very much. Hope that makes sense. It is not something you need to worry overly much. If you haven't, if you're watching this video after the CCMC, it won't have hurt you. It's more a vlog that gives you a little bit of golden practical legal knowledge to help you capitalise on an opportunity and score at least a mini tactical victory.